I do propose to speak about the topic of brokers and the duty of utmost good faith and where the duty falls in relation to the roles and responsibilities of the broker. But having the microphone for the last session, for those of you who know me well, I do like to go a little bit off-piste. And before I begin the presentation, I'd like to start first with a diversion and then with a digression and then get into the presentation. The diversion is simply this. For the last couple of days, I've been reflecting upon what it is that we've done in terms of this conference, and it reminds me of the Battle of Gettysburg, which I'm sure all of you know ran from the 1st to the 3rd of July in 1863. It was a significant battle in the Civil War. It was the first time that the Union Army had achieved a significant and decisive victory, but at some cost. Over 60,000 casualties on the field at the close of play, including the General of the Union Army, George Meade. It took the North by storm in terms of optimism. It took the South by storm in terms of a real turn in the fortunes of the Confederacy. But Lincoln saw it for what it was and decided that there needed to be a commemoration on the field of battle. And as was popular in the day, a person of some popularity in the country, a man by the name of Edward Everett, who was much more popular than Lincoln, was chosen to give the Gettysburg statement. And he rose and he spoke for 3.5 hours, something that I won't do. And there were many photos taken of Everett giving his address. Not one word of the address was written down. The President had been invited and he rose to his feet to deliver what has been described as the greatest piece of public speaking ever. 262 words, the Gettysburg Address. There is no photo at all of Lincoln at Gettysburg. The moment was not recorded, the moment was not celebrated. And I think here today, acknowledging the efforts of Alan and Greg in terms of seizing the moment, taking the photo of the 250th anniversary of Carter and Bohm, as someone with a deep interest in history and insurance, I applaud the two of you, and I think that all of the attendees at the conference do. So a moment of selfishness and a moment of diversion, but I applaud you guys' efforts in terms of capturing the moment. And to use the words of Lincoln, getting together is fitting and proper that we should do this thing. A slight digression. For those of you who may have read a little bit of my biography, know that I do have a deep interest in Lord Mansfield. I'm currently undertaking a doctorate in relation to his work, and we've already touched a little bit upon what Mansfield did in relation to Carter and Bohm. But to try and bring everything together, I think it would be very important just to spend 2 or 3 minutes looking at Mansfield's past to maybe try and get some understanding as to where he was coming from in relation to the concept of utmost good faith. And of course, the reference in his judgment is to good faith, and it's not long after that we had the subsequent decision where they actually used the phrase Uberame Fides. And one of the things that was interesting yesterday was Yong's presentation, where he talked about, is there a separate notion of good faith as opposed to utmost good faith, which is something that I'll touch upon in the actual presentation on brokers and how the duty of utmost good faith may fall into their provenance. So just a couple of words again on Murray, just following up on the incredibly interesting presentations of Robin. As he said, he was born in Scone Palace in 1705. The point here that I wish to make is just what an extraordinary intellect the man must have been. He won a scholarship to the Westminster School in London. He became a King's Scholar at the school, achieving the highest mark ever at the Westminster School, and was sent on a full scholarship to Christ Church in Oxford. He had an extraordinary career as a barrister, a politician and a judge, and has certainly been recognised as the most powerful British jurist of the 18th century. We're here today, of course, to talk about his seminal decision in Carter and Bohm, and I was amazed to hear Peter Mann say that this for him has been a turning on of the lights in terms of an understanding and a recognition that Carter and Bohm is probably the most important insurance law case. But it's only one of many decisions that Mansfield handed down that had an extraordinary impact upon the law of the 18th century, but also the law today. And in terms of the research, in terms of where did the concept of Uberima fides come from? Where did this notion of utmost good faith, or good faith as it's referred to in Carter and Bohm, come from? It is beyond doubt that Mansfield, almost unlike any other judge that came before him, was incredibly cognizant and in fact drew heavily on the lex mercatori, the maritime law of Europe in existence at the time, based more upon European concepts than common law concepts. And it seems to be the case that the notion of Iberima Fides that he puts to the fore in Carter and Bohm is one that is very much given to him by his deep commitment to the merchant and the trade industry in London at the time. And of interest, we know that on the jury in Carter and Bohm was a man by the name of Edward Bow, who was in business possibly with a man by the name of James Parker, who Mansfield constantly used as experts. And one of the things that you'll see in the judgment is that the matter is heard before a jury of merchants. So incredible use there of experts at the day. And of course, as we all know, Carter and Bohm, seminal case in insurance law. But just a couple of other things to put into perspective about how extraordinary this man was. Miller and Taylor, the first case that ever recognised the perpetual right of copyright in common law, and also gave rise to the notion of an author having moral control over his or her rights. Somerset's case that we haven't touched on at all, but was an extraordinarily important case. It gave rise to the concept that no man has ownership of another, an insurance dispute over a claim in relation to a slave that had been taken off a vessel in Liverpool, and also the Mills and Pierhope case, which was Mansfield's significant attempt to remove the concept of consideration from the law of contract, that he was successful in that case, but was subsequently rejected in English judicial history. So he sat on the King's Bench for many, many, many years. Only 6 of his judgments were overturned on appeal, and he was significantly connected into London society and English society. He was a very close friend of Alexander Pope, in fact wrote Pope's will, very closely connected with William Blackstone, and helped Blackstone draw up the lectures that were given at Oxford University that ultimately became Blackstone's Commentaries of the Laws of England, and was a very close personal friend of Sarah Churchill, the Duchess of Marlborough. And of course, Fort Marlborough brings us 360 all the way to Carter and Bohm and brokers. And what I want to touch upon now is just a quick reflection, 3 slides, where I just put out some general thinking in relation to how does the notion of the duty of utmost good faith impact upon the classic relationship between the insured, the insurer, with the broker hanging off the side. And I think it's fitting in relation to any conference where we talk about Carter and Bohm that we do give some consideration to brokers, even though Mansfield in that case did say the opinion of the broker we ought not pay the least regard to the opinion of the broker. So clearly that must have been Frank Hoffman's first case as an expert. So without further ado, thank you very much for allowing me first for that diversion and then that digression. I now just want to get into the presentation. I've only got 3 slides. There are much more eminently qualified people in the room than me to talk about this, so please feel free to interject, and I'm going to try and bring people in relation to some of the things that we've touched upon yesterday and today. So the first slide is this. We know from a legal point of view that when we talk about the concept of the duty of utmost good faith, we are really focusing in on this relationship. It goes both ways. Both the insured and the insurer owe a duty of utmost good faith to each other. And of course, in very simple terms, in the common law world, we know that when we talk about the duty of utmost good faith, we talk about normative conduct, incidental to the relationship, but still paramount. And of course, under the Insurance Contracts Act, when we talk about the duty of utmost good faith, we immediately think of 13 and also 12 in relation to the implied term in this relationship. So acknowledging that the duty really is all here, what is the role of the broker in relation to the duty? And the question that I want to postulate this morning is there a need, is there a duty for the broker to explain to the insured the nature and content of the duty of utmost good faith? And I think that the answer to that question must on balance be yes. We know on the basis of case law, both in Australia and in England and in other common law jurisdictions, that the broker has a fundamental role to play in explaining to the insured the duty of disclosure. And we know that the duty of disclosure in several of the cases, and I think in particular of the UK case, such as Jones and Environcon, and also in terms of what was said in the court in cases like Fanhaven, that the cases say that there is a fundamental requirement on the broker not to act as a lawyer in terms of explaining the duty, but certainly to act, and I think this is the language that Greg uses in his textbook, to act as the midwife to make sure that the duty of disclosure is significantly explained to the insured so he, she or it can meet its obligations to the insurer. And I think that if that's the case, that if we understand that the duty of disclosure is in many ways the way that the duty of utmost good faith is manifest on the shoulders of the insured, and also recognising and never forgetting that when you come back to Section 12 of the Insurance Contracts Act and we talk about the fact that the duty of utmost good faith is paramount in the relationship, I can certainly see that an argument can be made, and this is the point that I make in relation to this slide, that not only does the broker have an obligation to explain to the insured in the context of the broker-insured relationship what is required in relation to the duty of disclosure, but also what's required in relation to the duty of utmost good faith. Now, in relation to how that may actually manifest itself in claims and litigation and the like, one of the things that I've noticed recently in relation to the broker's negligence actions that I've been dealing with is that they are usually predicated upon a declinature by the insurer to the insured, and the insured classically turning around and saying to the broker, well, if I'm without cover, then it's all your fault. And I've seen a developing trend in the litigation, certainly in New South Wales and Victoria, that in matters of declinature, primarily for non-disclosure, the insurer will also make an allegation of breach of the duty of utmost good faith. And I think that one thing that may be agitating people's minds in the room is, well, what really flows from all of this, if you are saying that there is a duty to explain the duty of utmost good faith, if you don't do that, what flows from it, what sort of cause of action does it set up? But I must say that in relation to defending brokers' negligence cases, if you are looking to defend them forensically, not only is it good to sort of find things like the Section 22 notice, but it would be very helpful to be able to deal with the alternate pleading in relation to the failure of the insured to act to the insurer with utmost good faith. So that's just a couple of comments in relation to that particular paradigm. The next question that I wanted to reflect upon was just switching things around, and this is looking now not at this relationship, but looking at the relationship between the broker and the insured. And the question that I found myself turning my mind to was, does the broker ever owe a personal duty of utmost good faith to the insured? Now, in the short period of time that I actually had to prepare for the talk, I only had a couple of weeks, I was unable to find any case law, certainly in Australia, unable to find any case law in the United Kingdom, in England and Wales, that actually dealt with this issue of does the broker ever owe a personal duty of utmost good faith to the insured. There is, interestingly, one paragraph in the latest edition of Sutton, and it's my understanding that Ian Enright wrote that chapter, and this is the language that the chapter uses, and the chapter speaks in the positive, does talk about it as being a positive obligation, and the paragraph says that there are indeed circumstances where the broker will owe a personal duty of utmost good faith to the insured. It sort of seems for insurance lawyers somewhat counterintuitive, but I think we need to reflect upon the fact that contracts of uberem fides are not the exclusive province of insurance. For example, they do have application to partnership agreements. They do have application to certain exotic financial transactions. So there is no reason per se as to why you should simply walk away from this and say no. I think the reason why the word personal is used, and that's the reason just for the arrow there, is because I think I could never think of a situation where the duty would flow the other way as well. And just to finish off, the thing that people are probably reflecting on is, well, what are the circumstances where a broker may have this duty enlivened, a duty to act with utmost good faith to the insured? There's an interesting comment in the paragraph in Sutton which talks in terms of circumstances where the broker comes into the possession of extremely confidential, commercially sensitive information, and being the repository of that information enlivens this duty. I had an opportunity to speak to Robert Merkin last week when he was in Sydney to ask him about this. He said that he thought that this was right, and he also said that he thought that the new Section 4 and the relevant sections of the recent Insurance Act in the United Kingdom actually sought to sort of move in this area. And I think that one of the things that we're starting to see in Australia is, I think, a sort of an incremental approach beyond permanent trustee and FAI in relation to knowledge of broker issues, knowledge of the insured, knowledge of the broker. And if I had a little bit more time, I'd take you to that recent decision in Victoria of Calabacus, where they talked in terms of the need for further High Court decisions in relation to knowledge of the broker. So in relation to the first slide, is there a duty of utmost good faith? Is it something which needs to be explained by the broker to the insured? I think the answer is yes. In relation to this slide, I can see where Sutton is coming from, and we know too that there is a long history of cases in Australia where judicial notice and judicial acceptance is given, especially to works such as the addition of Sutton on insurance law. So then finally, just to kind of like complete the triangle as it were, just looking down here, does the broker ever owe a personal duty of utmost good faith to the insurer? Once again, my research could find no cases or text or commentary where this was dealt with. I did find one article written by an organisation that shall remain nameless, I think it was ANZIF, where someone from the industry actually said, yes, they do think that the broker can owe a personal duty of utmost good. They didn't use the word personal. They said that the broker, in fact, they spoke in very positive terms. They said that the broker does owe a duty of utmost good faith to the insurer. And if I had more time, but maybe on the way to the jungle or over a beer tonight, I'd be happy to tell you as to why I think that that is in many ways a nonsense. So there you go. I think I've got us through to jungle departure time. I think it's fundamentally important that we never lose sight of the importance of the broker in relation to the relationship between the insured and the insurer. And interestingly, as part of the preparation for coming up here, I spoke to a lot of clients who are brokers. Colin and I actually spoke to some very senior brokers when we were in Singapore last week, and without exception, every single broker that we spoke to said, what a good question. We have no idea what the answer is, but it sounds like something that we should be thinking about it. So thank you very much for your time.